The UNO, an international organization, was established to prevent war and maintain world peace and secure the political, social, and economic conditions under which this could be achieved. This was a topic that we dealt last time. Today, in our topic, we'll be dealing about with the major organs of the United Nations. In this context, we will deal about with the International Court of Justice. So its composition. The court began its work in 1946 when it replaced the Permanent Court of International Justice, which had functioned in Peace Palace since 1922. The International Court of Justice consists of 15 judges. The Security Council and the General Assembly each separately choose 15 judges. They are elected jointly by a majority vote. Their term is 9 years, with 1/3 judges retiring every 3 years. No two judges should belong to one country. If two persons of the same nationality are chosen, only the elder one becomes the member. The court also elects its president and vice president for 3 years term who can be re-elected. The court also appoints a registrar. Judges can be re-elected. The members of the court do not represent their governments but are independent magistrate. The judges must possess the qualifications required in their respective countries for appointment to the highest judicial offices or be jurist or recognized competence in international law. The composition of the court has also to reflect the main forms of civilization and the principal legal system of the world. For sitting of the court, the quorum of judges is 9, but a small court may sit to hear certain classes of cases. The headquarters of the International Court of Justice is in Hague, in Holland, or we call it Netherlands. Now coming up with the functions of the International Court of Justice. First point, if the treaties provide, the court can hear cases of disputes between two or more nations and decide it. Only the member states of the UNO are entitled to appear and apply. Disputes between nations relating to the reparation of interpretation of international law are heard by it. Second, in case a complaint is filed by one country against another and the respondent nation appears before the law court, then it can hear it and decide. The court interprets it as consent of the reference. The General Assembly, the Security Council, the UN organs and agencies may ask International Court of Justice to give its advisory opinion on any disputes, legal question within the scope of their activities. Since 1946, the court has given 24 advisory opinions concerning injuries suffered in the service of the UN territorial status in South West Africa, Namibia, etc. It codifies the international law by thoroughly examining the international conventions, customs, judicial decisions, and the general principle of law. It evolves the procedure of peaceful settlement of dispute. It may also recommend the terms of settlement at any stage of settlement of a dispute. Each country is obliged to comply with the decision of the International Court of Justice. The disputes are related to matters such as aerial incidents, fishing rights, asylum given by the government to foreigners who left their country. If any party fails to fulfill its obligation, then the Security Council can be approached, which can decide about the measures to be taken to enforce the decision of the International Court of Justice. The decisions are made by majority of the judges present. Thus, the International Court of Justice tries to bring about peaceful and judicial settlement of the disputes. So, in short, this is what we have for the International Court of Justice. The other three organs of the United Nations are not described in the syllabus for you all. I hope you have understood the International Court of Justice, its composition and function. Till then, we begin the next topic. Take care. Goodbye.